building a Britain where children come first. So these 91 amendments will extend all of the children not in school measures to Wales. The legislative consent motion is engaged in relation to this change, on which we're working very closely with the Welsh Government. And whilst the last government said there was no space in their King's Speech to ensure our children's safety and their education, for this Labour government, our children are a priority across the whole of the United Kingdom. And
I'm sure, absolutely sure, the Minister's intention is to ensure that this doesn't happen, but can she provide something that if people are doing a number of hours a week, is that really have to be recorded? Every place, I don't know how much the Minister knows about home education, but children are educated in all sorts of places, and I think there's a real opportunity at the dispatch box now to say that she'll come forward with regulations that make sure that they're not having to write down every time they stop at an ice cream shop because there was some education about the flavour of vanilla.
The amendments that I am addressing at the moment are particularly in relation to information sharing, which clearly he has concerns about. But members on all sides of the House will be all too aware of the succession of tragedies that we have seen when children fall between the cracks in services that should be there to support them. And the intention and purpose of the changes being brought forward in this legislation is a reflection of this government's determination to bring that era of state failure.
I also welcome the measures in the bill to introduce a register of home-educated children. While home education is the right option for some children who are well supported to receive education at home, the number of children essentially going missing from the education radar, out of sight, without any regulation of the quality of the education they are receiving, and sometimes coming to harm, as in the horrific recent case of Sarah Sharif, is deeply concerning, and the measures in the bill will help to address it.
Vulnerable children do not disappear from the system. However, we also strongly support the right of parents to choose to home educate where this is the best option for their child. However, when even the Association of Directors of Children's Services was circumspect when they gave evidence at Public Bill Committee, they were circumspect about the amount of information parents will be expected to supply as set out in Clause 26. A level of detail which I would say risks becoming intrusive and unnecessary. Ministers must think again. NC 48 therefore calls at the very least for a review of the register's impact on home educators to be carried out within 6 months to ensure that only reporting requirements strictly necessary for safeguarding purposes are retained. Amendment 224 would remove the requirement for carers of children in special schools.
To Amendment 173 on local authority consent for the withdrawal of certain children from school. Home education is an option that works extremely well for some families, and indeed many children thrive in this environment. Nevertheless, for vulnerable children, there can be real dangers in dropping out of sight of public agencies. This bill therefore rightly already mandates that if the local authority has live child protection concerns about a child because they are suffering or likely to suffer significant harm, then their parent must obtain the consent of the local authority to withdraw the child from school. Our amendment extends this to children for whom the local authority has previously had concerns and taken action under Section 47 of the Children's Act 1989 in order to safeguard and promote their welfare. The NSPCC, supported by the Children's Charities Coalition, has called for this strengthening of the bill's protections to safeguard the most vulnerable children for whom withdrawing from school poses a risk to their safety and welfare. Last year, the Child Safeguarding Practice Review Panel published their analysis of serious case reviews involving children who had died or suffered serious harm because of abuse and neglect. These children were not in school at the time under the proviso of receiving an education at home. Of the 41 serious case reviews, over half, 23 of the children, were previously known to children's social care, including being subject to a child protection plan prior to the time of the incident. Under Clause 25 as it stands, children like this would not be safeguarded, which I'm sure is not the government's intention. I therefore urge the Minister to seriously consider Amendment 173 as a proportionate and necessary safeguarding measure.
25 section 434A, the local authority must serve notice to both parents unless exceptional circumstances apply. For instance, Madam Deputy Speaker, in cases of domestic abuse or family estrangement. Yet Section 436C under Clause 26 requires the register to include the name and home address of the child, both parents' names and addresses, and the addresses of all places where education takes place. Crucially, there is no provision for exceptions in cases where sharing this information could put children at risk. One of my constituents, whose name I will protect for obvious reasons, told me, "Since 2018, I have managed to keep my home address private from my ex-partner. Throughout the court case, I was supported to keep my address private, and it was never included in any document he would have access to. This register will hand him our home address, details of my new relationship, the names and addresses of my new partner's parents who will support me. It will hand them the address of every activity my child attends. This proposed register essentially hands him motivation, evidence, licence and opportunity to continue his coercive controlling behaviour. Currently," she goes on to say, "we are safe. My daughter is known in the home education community. She is not hidden. She is not missing education. But this bill will put her in danger. It will put me in danger. It will put my baby with my new partner in danger. The current provisions of this bill will not increase our safety, and I have no doubt there are hundreds of other mothers in the same position across the country." Chilling indeed. To address this, Amendment 175, introduced in my name, provides the same safeguarding expectations already present in Section 434A, removing the requirement to provide sensitive information where there is a known risk to a child. I'm also concerned about the excessive reporting requirements included in the register, other than the reference to ice creams. While basic information is useful for future planning, Section 436C subsection 1E goes much further, requiring details of all individuals involved and a full list of all activities. This not only places an unrealistic burden on families, but is also impractical for local authorities to manage. And if we break down what's being asked, it would mean that parents must report a neighbour who teaches their child to cook or sew, a local farmer who introduces their children to their environment through hands-on experiences, swimming lessons, museum visits, or even regular nature outings with other home educating families.
Would you accept an intervention?
Of course.
I thank my Honourable Friend for accepting the intervention. Would she also accept in this vein that, as I mentioned, grandparents reading to their children can be considered home education, and they should be inspected and reported upon. But also, vital home education groups that are provided free of charge could be driven out of business by the scale and weight of reporting they'd have to provide.
I thank the Honourable Member for his intervention, and I think a lot of people who don't know anything about home education miss the fact that there is a whole community of home educators. Those children spend plenty of time with their peers. They're just different peers. Other peers that prefer to have their education done outside of a school environment, and there is a risk to those organisations being driven underground or lost altogether. Under Section 7 of the Education Act 1996, parents already have a duty to ensure that their child receives a suitable education, whether through school or otherwise. And local authorities can already conduct informal inquiries and issue school attendance orders if they believe a child is not receiving an appropriate education. So this is just simply overkill. A formal register would help to ensure accountability, but this is an overreach. So my Amendment 221 proposes a more practical solution, requiring only those who provide more than 6 hours per week of education or activity to be included in the register, striking a reasonable balance, ensuring that key educators are identified without overwhelming families or local authorities. And while there are genuine safeguarding concerns, local authorities already have the power to intervene under Section 47 of the Children Act 1989, and the Victoria Columbier Foundation actually stated that this act would have done nothing to help Sarah Sharif because the local authority had already decided that that child was not at risk. Would you like me to give way?
I'm grateful to the Honourable Lady for giving way. I hope colleagues in the other place will follow up on the Honourable Lady's excellent speech. Focus in on this. If a register, which the Honourable Lady supports, I don't, but if it does go ahead, it should start with the minimum requirements and then could be expanded if needed, rather than this spread out position. And I also, just to reinforce the point she makes, local authorities already have the power to intervene if it appears to them that someone isn't having a suitable education, and has all the powers that is required if there are concerns about welfare. So conflating welfare and education the way this bill does is something which particularly irritates and upsets home educators.
I thank the Right Honourable Gentleman for his intervention. In fact, Catherine from my constituency wrote me a very long email talking about welfare versus this, two totally separate issues, and they're really upset, and they would have been devastated and distraught to hear the member from Morecambe and Lonsdale effectively make them feel like they were some sort of pariahs. I was really upset to hear that, especially as I did ask my home educators to listen to this debate and give me their feedback. I also want to support the amendments submitted by the Honourable Member for Sevenoaks, Amendments 195 and 197, seeking clarity that educational activities outside of regular school terms should not be subject to this overreach. My children aren't subject to them. Children in home education should not be subjected to anything more than the rest of us. And those children receiving education out of school should have the same rights to take their public examinations as their peers. It should not be based upon a parent's ability to fund this. After all, the Treasury is already saving many thousands for every child who is home educated, so this token of support to parents covered under New Clause 53, submitted by my friend the Honourable Member for Twickenham, providing a child to sit any relevant examination and to be fully funded where requested. I do want to thank the Minister for her confirmation. As I sat here this afternoon, I received a letter to say that the challenges faced by summer-born children are going to now be considered.
Decision to withdraw their child from a school where their needs are not being met. Unfortunately, though, not all parents who remove their child from school are motivated in the same way or are providing a decent education. Sadly, there are too many cases where children who are classed as home educated are actually attending the illegal settings that I set out earlier, or are simply not receiving any education at all. In the worst cases, like that of Sarah Sharif, we have seen children removed from school in order to prevent detection of abuse. It's only with this bill that this can be tackled. The introduction of registers for children not in school is crucial in ensuring that children don't fall through the net. So I want to reassure...
Would the Honourable Lady accept that in the case of the tragic case of Sarah Sharif, which my honourable friend on these benches has been pursuing, the killing, the murder happened in the school holidays, and that she was already known to social services. So the fact that she was, and there's not much evidence that the parents said they were going to home educate in the first place. Given all those facts, would you accept that there is actually no correlation in the data between children who are home educated and children who are ultimately judged to need a care plan?
I thank the Honourable Gentleman for his intervention, and I would like to acknowledge the complexity of that case and the failings that Sarah saw before her death were abject across many organisations and were absolutely unacceptable. However, it is the case that she was removed from school partly so her parents could prevent the detection of that abuse. Now, I have recognised, and I will continue to recognise, that obviously this does not speak to the vast majority of people who home educate their children, but the fact is, as parliamentarians, we have a duty to protect the most vulnerable. And sometimes that includes regulating the majority who are decent, honest people. So I want to reassure parents that the new regulations, such as registers for children not in school and the capacity to compel school attendance in certain cases, are not aimed at limiting home education as a whole or about policing how people choose to educate. I will happily give way to the Honourable Gentleman.
The Honourable Lady for giving way. But the intention isn't the thing, it's the actual impact that's the thing. And if you've taken your child out of school for reasons that the Honourable Lady said, perhaps an autistic child, miserable every day, after letters to the head teacher, the local authority, failure after failure, you've forced to go into home education yourself, to have a representative of that failing local authority as far as that parent is concerned, coming in, possibly having the right to enter the home and sit in judgment on the child that you have been forced to home educate. Can she understand why parents are very fearful of this imposition, especially after so many years, successive governments failing to provide any proper support for home educators, but very happy to come forward with a hard top-down register?
I thank the honourable gentleman for his intervention. I accept wholeheartedly the amount of parents of children, particularly with SEND, who have been absolutely failed by our system, absolutely failed by 14 years of Conservative government. What I don't accept that this is somehow a major imposition, that checking that children are receiving a decent education, checking that children are safe and well cared for. I do not believe that is a major imposition on parents, and all good parents, I think, would welcome that. These measures are being put in place to protect and safeguard vulnerable children. Having no oversight of children not in school is an unacceptable risk to children's welfare. The Children's Wellbeing in Schools Bill is crucial and can't come too soon, Madam Deputy Speaker.
A key group in my constituency who have ardently opposed the state-controlled education is home educators. Home education is a provision used by many parents across Farnham, Borden, Hazelmere and Liphook because it provides a more personalised approach to learning, which in some cases benefits certain children. Now, Clause 200 mandates local authorities to submit a statement of reasons when they do not agree for a child to be home educated. Families are deeply concerned that the government's original proposals impose excessive state control over home education, failing to recognise the dedication and that care home educating parents provide. And the Honourable Lady opposite, in the speech I've just before mine, said, and I think I'm quoting her correctly, said, all good parents would welcome this imposition on the education. But that's simply deeply unfair to all the good home educating parents that have contacted me. They do not feel that this is a proportionate measure. They think it is a deep imposition, and they are good home educators. Now, Clause 200 is a more proportionate way to address concerns while still ensuring the accountability that the Honourable Lady opposite wanted. This is especially important for families with SEND children awaiting EHCPs, a process that can take up to 2 years. In my local area, 17% of independent school pupils receive SEND support, yet only 6% have a formal EHCP. And so therefore home education, especially in that interim gap between realising you need SEND support and receiving an EHCP, is often the best option for these children. Clause 202 removes the requirement for local authorities to approve and consent to home education of children with special educational needs. Removing these bureaucratic hurdles empowers parents to make the best decisions for their children and ensures inclusivity and equity in education.
For giving way. Could she reassure home educating parents that the requirements in the bill aren't going to be overly onerous? For instance, having to record the time that each parent educates the child. When is that? Is that 24 hours a day, 7 days a week, 365 days a year? How exactly will that work? And can she give some reassurance that this can be made to be manageable and sensible and not disproportionate?
Children who are doing the right thing, home educating their children, providing a suitable level of education in a safe environment, have nothing to be concerned about in relation to these measures. These are intended to ensure that no child falls through the cracks, and that's what we are delivering.
Conflation of children being educated otherwise than at traditional school with safeguarding concerns isn't borne out by the evidence. It is also an ideological position, which is, of course, an insult to the 110,000 children, their families, their parents, our constituents up and down the country who are doing a great job on ensuring their children are educated, whether they're home tutored or, for example, are educated otherwise. In fact, according to the local authority data published in academic research, which has been submitted to the Select Committee, only 11% of Section 47 child protection inquiries into home-educated children result in a child protection plan. That rises to 26%, so more than double for the average child, predominantly educated at school. So children, child for child, those who are educated at home, are in fact safest and least in need of protection. So it does not justify this overwhelming weight of new bureaucracy and legislation which seems to be tackling home education as a sector. Therefore, my honourable friend's new clause 48 is quite right, which would remove the burdensome and highly intrusive sanctions against those families.
In relation to home education, I recognise the importance of safeguarding and making sure that vulnerable children don't fall through the net. However, the home educating community is growing, is diverse, is caring, and they are fiercely passionate about their children's education and learning. Amendment 4 and 13 and 14 in my name is about adding the definition of suitable education, which already appears in Section 7 of the Education Act 1996. Without this amendment, it will be left to individual local authority officers to decide what they think is suitable education. Amendments 5 and 7 in my name are about registration and the contents of the register, which would make it no longer compulsory to provide the second parent's name if it's not relevant to the child's education. If the second parent's name is not mandatory, then the lone parent cannot be sanctioned for failing to supply it. The requirements for two parents' names disproportionately impacts single parents who may have to make an impossible choice between provoking their ex-partner or see their child forced back into school. Failure to comply may result in the lone parent having to choose between sending the child to school, which may not be the best place for that particular child, or facing fines and potential imprisonment. Amendments 8 and 12 in my name are about the school attendance order process and would remove the use of school attendance orders, conditions C and D, or D, where a parent is unable or unwilling to provide information for the register. Amendment 15 to 19 in my name are in relation to home visits. Home visits are a part of the school attendance order process, and it adds that there must be something about reasonable grounds for refusal on the face of the bill. A child may be extremely anxious about strangers in their safe space of home who are about to scrutinise how much they are learning and who have the power to send them back to school if they deem it to be insufficient. A parent may therefore feel compelled to refuse a home visit. This should not be the reason to fail the home education, hence it should be added on the face of the bill that reasonable grounds may justify a refusal. It cannot be simply left to guidance on a later date. Furthermore, it would be using a sledgehammer to crack a nut if the local authority had a statutory duty whereby it must consider all the settings where the child is being educated, since there must be constantly evolving venues and activities. Instead, it should say that the local authority may consider some of the settings. These amendments allow reasonable grounds for refusing home visits, which would also mitigate the use of school attendance orders for discrepancies in registrations. Conditions C and D under 436H6 and Clause 7, which would otherwise have a disproportionate impact on lone parent households, mostly headed by mothers. Details of both parents will be required for the register under the proposed new section 436C, while section 436D imposes a legal duty on parents to supply this information. Without these amendments, section 436I could see a situation where a lone parent who is scared to supply information about an absent parent or a former partner is put at risk of reprisals from the non-resident parent whose address will also be visited as one of the homes in which the child lives. Finally, a message from many of my constituents who are home educators. There are some who may say that home educators do a good job, but, and that's it. A whole community dismissed in 7 words. Just for once, can we acknowledge the thousands of families taking responsibility for their children's education, often through shortcomings in the school system, as was rightly alluded to by the honourable member across the bench, in the school system. Their work and that of their children should be appreciated and valued. We should not stigmatise home education. If adequate child protection laws and systems fails, it is that which requires scrutiny.